The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of IJ's Center for Judicial Engagement, as well as IJ attorney par excellence, Renee Flaherty. This week on the show, sexual assault on campus, a spurious arrest, an interrogation without a lawyer, and some ill-considered comments at a sentencing hearing. Renee, let's start things off in the Second Circuit.
Sure. This case is about a Columbia student who was accused of sexual assault and ultimately suspended for a year and a half. And then he sued Columbia under Title IX for sex discrimination because he alleged that they failed to properly investigate his case or inform him about his rights and basically just accepted the accused story without question. And this is all going on at a time when Columbia had been criticized for not properly investigating sexual assault claims. And in fact, the woman who was in charge of his investigation had been personally called out during all of that controversy. So there's a lot going on that makes his allegations particularly plausible, but the district court dismissed his case. But the Second Circuit here overturned that dismissal and holds that all the student had to do was allege facts that give rise to a plausible minimal inference of bias. And as a kind of boring procedural point, the court concluded that the same pleading standards that apply in employment discrimination cases should also apply in sex discrimination cases. And that means that the plaintiff should get a favorable presumption. And I think that's right because a standard on a motion to dismiss should be really low and it should be favorable to the plaintiff. And when I first read this case, I thought that it totally turned on the standard of review. But as it turned out, the court in this case really did dig into the facts. And it's a really interesting opinion no matter what you think of the underlying merits, which, of course, the court totally made clear that it had absolutely no comment on.
Right. So this case is in part about procedural posture. This is not whether the student's claims are valid, but whether the student even gets in the courthouse door in the first place. But it's also a very vivid illustration of what judges can do to reconstruct facts in a way that enables them to draw logical inferences about official behavior. You look at these facts, you can take them in independence or you can take them in a broader context that embraces not only what given officials did in a particular instance, but an entire backdrop where university officials and the official whose role in this investigation is actually most key are suffering from criticism as a consequence of not pursuing sexual assault allegations sufficiently. And when you frame it in that context, the student's claims appear more plausible than they otherwise would be, and you're able to see what judges can do to draw inferences from official conduct about the intentions that government officials are pursuing in cases.
So, Renee, what happens next in this case?
It goes back to the district court. Like Evan said, the student is actually able to get in the courthouse doors, and that's really important and shows what an impact procedure can have on substance.
Yeah, and I think the point that we can make more broadly about this case is that you sometimes hear courts saying, look, we can't possibly, particularly in our economic liberty cases, we can't possibly understand the motivations that legislators were pursuing when they passed this regulation that doesn't seem to do anything but privilege one set of industry competitors over another. We can't get into their heads, therefore we can't find what they have done to be unconstitutional. Judges are capable of reconstructing facts and setting them in a broader context that enables them to draw logical inferences about why individuals acted as they did. And in this case, I think that you have a very vivid illustration of how they're able to do that. Again, this is not an adjudication on the merits, but the way in which the judge in this case reconstructs the facts in a way that enables you to see how there's a plausible claim of discriminatory intent, I think, is very telling.
Okay, let's move now to the Ninth Circuit. Evan?
Yeah, this is a fascinating case. It involves a gang-related shooting in Los Angeles and an individual who's convicted of murder for driving the car from which this drive-by shooting took place, injured a couple of teenagers and killed one. He subsequently seeks a writ of habeas corpus alleging that the interrogation that eventually produced incriminating statements that were used against him at trial perpetuated a violation of his constitutional rights in the following sense. At one point during hours worth of interrogation by police officers, in which the police officers, as police officers are wont to do, made the case against him a lot stronger than it was. To put it bluntly, they were lying to him about some of the evidence that they had against him. He says, "I don't want to talk no more." And the police officer does not stop talking to him, does not respect what the court later concludes was an unambiguous invocation of his Fifth Amendment rights to remain silent, but continues to question him, continues to talk to him, and eventually says, "Yes, I drove the car." And those statements were used against him at trial and produced his conviction. The question in this case is whether, by saying, "I don't want to talk no more," he was unambiguously invoking his constitutional rights, or whether in context he was just expressing frustration. The court said unambiguous invocation of constitutional rights.
There's a dissent in this case. Renee, would you like to talk about that?
The dissent is by Judge O'Scanlan, and I think it's actually very reasonable, even though overall I think I agree with the majority. I think the dissent makes clear that this is not at all a clear-cut case, and it says that "I don't want to talk no more" is actually not an ambiguous invocation of the Fifth Amendment, and that it all depends on context.
And what context is present in this case?
Well, the context that's present in this case is that after the individual, his name is Kevin Jones, says, "I don't want to talk no more," the detective who's interrogating him doesn't bombard him with a bunch of subsequent questions. He says, "Look, I understand, but," and then Jones continues to talk. So it's not a situation that lends itself to, well, he stood on his rights and then the detectives just continued to barrage him. It's in context. Do we think that he was really standing on his right to remain silent? And based on the sequence of events, it's a questionable case. I mean, I think what's broadly going on in the dialogue between the majority and the dissent is not just a fight over this particular case, but about Miranda more generally. Miranda was articulated at a time when police interrogations, the third degree, were common. They were highly coercive. Miranda was a prophylactic rule articulated to put an end to that, such that as soon as a criminal defendant said, "Look, I don't want to talk no more," or "I'm invoking my right to remain silent," or "I want a lawyer," the conversation ended. Subsequently, the Supreme Court would cut back on Miranda, and now we have a very different rule that says, look, it's got to be unambiguous and discreet. And what you're seeing in the fight between the dissent and the majority is really not just about this case, but about the broader trend of our jurisprudence.
I think it's interesting that there's all of this hemming and hawing over, whether we should extend Miranda and about California precedent and about the standard of review. But I think it all comes down to these judges' intuitive gut feeling about what happened in this case. And you can get a really lengthy opinion out of that.
Mm-hmm. And the other point worth making here is that judicial engagement doesn't dictate outcomes in particular cases. It focuses on the kind of analysis that judges apply. Both the majority and the dissent in this case are applying careful, fact-sensitive judicial review. They come to different conclusions, but I think it's fair to say both the majority and the dissent are engaged in this case.
Okay, well, let's move on to the next case, which comes out of the Fourth Circuit. Renee?
With compliments to Evan and John, the cases on Short Circuit are never boring, but I think that this case in particular is really vivid and really fascinating. In the first place, you've got a qualified immunity case that actually comes out in favor of the citizen, which is basically a unicorn. And this case starts out, as all great cases should, with someone punching someone else in the face. Which is fantastic. But his mother gets arrested for obstruction of justice. And the Fourth Circuit says there's absolutely no way that police had probable cause to arrest this woman. So it starts out with this fist fight, and the officer who's investigating it finds out who it is and gets a warrant for his arrest. He calls two other officers for backup, and they arrive on the scene first. And they find this guy sitting on his porch. And he freaks out. He runs inside, starts yelling, and wakes up his mom, who is sleeping on the second floor. She comes downstairs to talk to the officers and says, all right, hang on, I will go talk to my son. And he's in the kitchen on his cell phone with his girlfriend discussing whether or not he should flee, and his mother talks some sense into him. It doesn't happen immediately, so after a few minutes, she goes back out to the officers and says, hold on just a minute, I'm talking to my son. And then she goes back to the kitchen where she's talking to him, which is not visible to the officers. And eventually the son comes out. And on his walk from the kitchen to the door, there's some commotion. The officers come in and grab him. They trip on some doggy gates, which whenever I was reading this and saw the word doggy gates, I immediately became afraid of what might happen to the dog. But you'll be relieved to know in this case that nothing happens to the dog. But the son does get arrested. And the first officer then goes to a magistrate to get a warrant to arrest the mother for obstruction of justice, which is just absolutely insane. And initially, the magistrate denies the warrant application, but the officer goes back to the other two officers, and one of them says, well, at some point in this encounter, the woman shut the door on me. And so armed with this new information, the officer goes back to another magistrate and actually gets the warrant. And the mother justifiably sues and says there was not probable cause to arrest me for obstruction of justice. And the court says, the court agrees and says, this woman is acting about as reasonably as you could expect anyone to act in this situation. And the Fourth Circuit overturns a grant of summary judgment for the police. And it's important to note that when you're on summary judgment, the court had to take the plaintiff, the mother's version of the facts as true. And like in the Columbia sex discrimination case, when I was reading this, I thought, well, this all turns on the standard of review. But like in the other case, you've got the court actually digging into the facts here. The Fourth Circuit actually goes through the officer's account and says it was not plausible. And the plaintiff's, the mother's, actually is more plausible.
Yeah, one of the important points that the judge makes in this case with reference to the officer's explanation of events is that speculation as to what was going on when the mother was not in their sight doesn't play a role in the probable cause inquiry. They speculated that when she was away, she was telling the son to run, and as a consequence, that was obstruction of justice. But she left, she returned, she left, she returned in a very short period of time, and all you had to support that claim on the part of the officers was their bare speculation. But mere hunches do not amount to a probable cause inquiry. Furthermore, in the context of Virginia law, which is the applicable law in this case, the Virginia Court of Appeals had actually held that fleeing from officers for a period of 4 hours did not amount to obstruction of justice. And yet we're supposed to believe that these officers reasonably believed that a brief period of interaction with her son, whatever the content of that interaction was, amounted to obstruction of justice. It was ridiculous. And the idea that the officers could have reasonably believed that they had probable cause in this case was sufficiently outrageous to the judge that he, despite everything that we've encountered with respect to qualified immunity, he was moved to rule in favor of the mother.
Evan, I don't see how you rule against the police here because, after all, they did have an arrest warrant from a magistrate.
Right. So this decision is actually very effective in repudiating the idea that simply because you can get a magistrate to rubber stamp your warrant, you're therefore off the hook if you violate the Constitution. The court makes the point that even if the magistrate was moved to rubber stamp your application, if you did not have reason to believe, objective reason to believe, that a crime had been committed, that she really had obstructed justice, then you're on the hook for the consequence. And the court makes plain that given the facts and independent of the officers' hunches, they did not have reason to believe that obstruction of justice had taken place.
Okay, let's move on to the final case. Evan?
So this case comes out of the Seventh Circuit and involves a routine guilty plea and a not-so-routine sentencing hearing. Billy Robinson pleads guilty to a couple of counts of heroin trafficking. Apparently he joined up with his cousin's heroin trafficking ring for a couple of months. as it would happen, a couple of months during which the relevant authorities took an interest in this heroin trafficking, and he eventually sold drugs to a confidential informant and ended up in, well, the situation that he's in. The judge imposed a sentence that's within the federal sentencing guidelines, but he did so after engaging in a series of soliloquies about urban decay, about the pathology of certain neighborhoods, of the connection between Milwaukee's riots in 1967 and Baltimore riots about police abuses, all of which came to a point where the Seventh Circuit concluded that, whatever his sentencing had been based on, it's not clear that it was based on factors that were actually relevant to those set forth in the guidelines.
So if an appeals court's going to look at sentencing decisions, it needs to be able to review discrete facts, and those aren't present here. He went on kind of a rant.
That's true. I think this is a case where the Seventh Circuit just absolutely had to do something, because a judge needs to have reasons for a ruling, and those reasons have to be clear. And the rant that the judge went on here made it not clear, even though there may have been reasons for the sentence interspersed within that rant. It just made it incredibly unclear.
Yeah, I mean, the key point here is that even if the judge could have justified the particular sentence that he handed down on the basis of relevant criteria set forth in the guidelines, our commitments to fair sentencing and fair procedures prior to sentencing is so great that we actually empower, appropriately, appellate courts to go back and say, look, you haven't actually shown that the sentence that you imposed are grounded in these factors. So even if you could have come up with exactly the same sentence, if you did so for the wrong reasons, that's illegitimate, that's improper, and reversed and remanded.
Okay, that concludes the show. Thanks for listening. We appreciate you. Until next time, this is John Ross from the Institute for Justice, fulminating at you to get engaged.